Good evening, everyone. Speaker of the day, Mr. Satyabrata Kumar, Joint Director, Enforcement Directorate, Vice President Narayan Pasari, Convener of the Corporate and Allied Laws Committee, Kinjal Shah, all those who have just logged in and viewing this telecast live, seniors, ladies and gentlemen. On behalf of the Bombay Chartered Accountants Society, I welcome you all to this lecture meeting on Prevention of Money Laundering Act and its implication on assurance and advisory services provided by chartered accountants. Globally, money laundering transactions are estimated at 2 to 5% of the global GDP, or roughly US dollar 1 to 2 trillion annually. Yet, according to the United Nations Office on Drugs and Crime, less than 1% of the global illicit financial flows are currently seized by authorities. With the rising visibility of terrorist attacks, money laundering and terrorist financing are escalating as priority issues for government across the globe. Over the past few years, in the US alone, nearly a dozen global financial institutions have been penalized, with fines running into hundreds of millions to billions of dollars for money laundering and sanctions violations. There are strong indications that other countries will follow substantive regulations and enforcement to counter the menace of money laundering, which is very much linked to terrorism. Anti money laundering legislation, which is prevalent worldwide, is not just for financial services institutions, but it brings within its ambit various organizations that facilitates financial transactions, including NBFCs, digital mobile payment services, microfinancers, insurers, mutual funds, to name a few. Alarmingly, but not surprisingly, many of these participants are not yet fully equipped and aware about the onerous requirements that they must fulfill to comply with the AML regulations. Money laundering not only destroys value but facilitates economic crime and nefarious activities such as corruption, terrorism, tax evasion, and drug and human trafficking by holding or transferring the funds necessary to commit these crimes. It is detrimental to an organization's reputation and its bottom line. The Prevention of Money Laundering Act 2002, which extends to whole of India, including Jammu and Kashmir, came into force with effect from 1st July 2005. Major amendments to the law were made in the year 2009 and 2012. However, PMLA has been in news in recent past, as in many cases PMLA is being regularly invoked and concrete action is visible, and in some cases the same has been invoked against professionals closely associated with such persons as well. The language of Section 3 of the PMLA has widest possible amplitude to cover professionals who either directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or actually involved in any of the process or activity connected with the process of crime. So as professionals, are we taking enough care? Are we doing our own background check on our clients or KYC before accepting any new clients? Are we ensuring that we do not deal with clients who are engaged in various criminal activities included in the schedule of the PMLA? To educate us and even caution us, we have amongst us the person who has dealt with various cases under PMLA and who will share his first-hand experience. Please join me in welcoming Mr. Satyabrata Kumar. As a brief introduction of the speaker, Mr. Satyabrata Kumar is an IRS officer of the 2004 batch and is currently Joint Director heading the Mumbai Zonal Office Western Region of the Enforcement Directorate. He has vast experience in investigating foreign exchange violation, including FDI, FCCB, ECB, and current and capital account violations, anti-money laundering investigation, serious fraud investigation, and is part of the international anti-money laundering efforts. He has also served as the Deputy Commissioner of the Central Excise and Service Tax, as an Assistant Director, Revenue Intelligence DRI, with experience in assessment, valuation, anti-evasion, law enforcement, and anti-smuggling field. To his credit, he has got several high-profile cases that he's investigated or are under investigation. The famous one, the recent one being Chhagan Bhujbal, then the then the Sahara, Kingfisher, NSEL. So please, once again, welcome Mr. Kumar. Before I request him to address us, may I request VP Narayan to offer him a memento as a mark of our respect and gratitude. Mr. Kumar, please.
Thank you for your kind words. Uh, Actually, you have summed up the PMLA Act very nicely. The Section 3, as you have rightly mentioned. Yeah. So that you have summed up the Section 3 of PMLA very nicely, and actually that is the crux of the PMLA. First of all, I will like to express my gratitude for you inviting me for this function, for you delivering a lecture. It's always a two-way discussion, a two-way transmission of knowledge, because we whenever we deliver a lecture, we also learn many things, because there will be so many questions will be there, and so it gives a new perspective to us also. And during the tea, we were discussing with Mr. Chetan and Mr. Narayan Pasari and Mr. Kinjal. So I am really very impressed by the types of that lectures you are organizing, or training sessions we are organizing. And I was really thinking that maybe we can organize a joint training for our officers also, so that, because nowadays many new officers are joining in enforcement directorate, so we need really to train them to, for them to have a perspective of what is PMLA and what is FEMA. And if we get a professional's perspective, because our perspective, maybe we have a certain way of working, government has a certain way of working, and our understanding is because of that way only, because you have a 360 degree perspective. You understand from the client side also, you understand from our side also, you know the regulations also, banking sector also, so it will be really beneficial for us. So now, starting with the uh, I think that is not my. Actually, last 2 3 days, High Court is keeping us busy, because that Chagan Bhujbal, now he has filed a petition under this uh, habeas corpus. After 8 months, he has filed a habeas corpus. Now he is alleging that his detention itself is illegal, and there is cost should be imposed on the department. That he was such a such a gentleman has been arrested. So we were just justifying the court, satisfying the court that no, we have arrested him, we have followed all the procedures and everything what was there in that. So these issues in Chagan Bhujbal case only, we are facing 75 cases under special court, high court and supreme court. All the accused, they first go to special court and then to high court and then supreme court, and it's an unending process. So it becomes really very difficult to investigate also. But let's come to that PMLA. So that, as it has been introduced by Mr. Chetan also, PMLA was of 2005, 2002, but it was enacted in July 2005. So it was, the main basic was that there was international obligations, because there was one FATF, Financial Action Task Force, was constituted. So the members of Financial Action Task Force, there were 7 members, and they had their convention, and they thought that this money laundering activity has very severe implications on the economies of the countries. Not only the terror funding is not only impacting a certain economic sector, but the security of the country, sovereignty, integrity of the country is also under threat. So some serious laws and international effort needs to be created. There should be a concerted effort by all the countries of the member countries. So with that it started. Then in UN there was a political declaration and global action program of action. So a resolution was adopted in the UN in 1990 that we need to have a special act or special law in all the countries, and the law which should be uniform all across all the countries. So that law that became the basis or genesis of the PMLA. So in pursuance with the FATF declarations and UN special sessions held in 1998, PMLA was enacted by the Parliament. So PMLA is a special law. Special law means it has been created for a special purpose, for the purpose of curbing the menace of money laundering and terror funding. So it provides for there are two pronged approach for PMLA. If you see, there are two approach in the PMLA. There are two things are to be done in the PMLA. One is that whatever the monies have been earned by these people through these scheduled offense or whatever offenses are there by committing those offenses, that money has to be immobilized. They should not be able to enjoy the fruits of the proceeds of crime. So the second is that they should be punished for this money laundering activities also. So there are two pronged approaches there. One part is partly civil, that attachment of property, seizure of property is there. For that we have separate process. Second part is punishing that the criminal or for the offense of money laundering. So for that we have special courts have been enacted, and that is a criminal process. And then this 3 to 7 years jail term is also there. So what is money laundering? Actually, the money laundering is not what we see in the local common parlance. What we see that everything someone is has black money, but black money and money laundering is not the same thing. For money laundering, you have to have a predicate offense. There are certain offenses which the government, in its wisdom, have made that these offenses are the predicate offenses which will attract the money laundering provisions of money laundering. If certain offenses have been committed under certain these predicate or scheduled offenses, so then if the money has been generated out of those offenses, then that will be the money laundering. So unfortunately, income tax violation of income tax is not a predicate offense. So income tax offenses do not constitute a money laundering. So first thing is that there should be a predicate offense. So there is around 32 acts are there which constitute the predicate offense. Main being IPC is there, cheating, forgery, criminal intimidation, trespassing, murder, attempt to murder, all those things acts are there. Forging of the documents, all those 468, these acts are covered. Then there are certain other important acts also, like that Wildlife Act is there. Suppose some smuggling is being done of the wildlife animals or something, or some poaching activity is done. So that also falls under the Scheduled Act. Then NDPS Act is there. Then other environment protection acts are there. So these acts constitute the then Prevention of Corruption Act is also part of it, a very important part of it, Prevention of Corruption Act. Then for SEBI also, SEBI Act, Section 12A with read with 24. That is, in the case of insider trading, if SEBI registers a prosecution complaint, so that becomes a predicate offense for the Enforcement Directorate. Like in Sahara case, what happened? There are two Sahara companies, SIRECL, SHICCL. So these two companies had made through private placement. They collected money to the tune of around 15 plus 22,000 crore was collected by these companies. So in that case was investigated by SEBI, and there was some around 3.28 crore, 3.29 crore investors were there. But when the SEBI issued that advertisement, hardly anyone came forward to claim that money. So then it became violation of this private placement act, because in the private placement only 49 or less people can be more than 50 people, it will not fall under private placement. So that it became violation of 12A. Then they filed prosecution complaint under section 24. So then we picked up the case from there. So these are the predicate offense. So one of the most important ingredient is the predicate offense. So there should be a predicate offense. Some FIR should be there, some complaint should be there by the level of additional secretary to the government of India. So based on that, money laundering investigation can be started. Now, what is the second part? Second part is some proceeds of crime should be generated. Suppose I have committed some offense, some criminal activity has been committed, but I have not gained anything out of it. Suppose I murdered someone, but it was in the fit of passion. At that time, there were some situations I murdered someone, but I did not gain anything out of that. So, self-defense or whatever be the reason. So that will not attract the money uh, PMLA because there won't be any proceeds of crime. So there should be substantial proceeds of crime also generated out of that criminal activity that has taken place. So then third is placement, layering, and integration. They cannot be necessarily in the same order. But suppose I have earned some money. So if I keep money like that, I won't keep it like that. I have to invest it somewhere. I have to keep it somewhere so that after a passage of time, people won't be able to associate that money with the crime. There should be delink. The crime and the money should be delinked. In future, if you want to use or enjoy that money, so it should not be that no, that it should be linked with that criminal activity. Then I can be caught anytime. Suppose what the international terrorists or other people are doing, they are having some parallel legitimate business, and they are showing their income coming from that business, so that they are able to enjoy the proceeds of crime. Though the money is maybe generated out of that criminal activity, but they are trying to show it as untainted money. So that placement, what do? They do that placement. That money is placed into the financial system. Then it is rotated through 3 4 accounts. So then it becomes, and then it is integrated into the system. That suppose I have earned money out of kidnapping or ransom or something. So what I will do, I will 50 accounts will be opened. I will deposit 49,000, 50,000 in that in those accounts, and then from those accounts I will RTGS to some company whose directors will be dummy director, my driver, or my any person, my rickshaw puller, whatever, will be the director of those company, and from those company I will take an entry into third company, and then in third layer or fourth layer, maybe I will export this item. I will show it as import advances. I'll send it to Hong Kong, and from there Hong Kong I will bring it back as a FDI. So this is called layering. So once it comes as FDI in India, it becomes a holy cow. No one, no one, no one can question that because that link is broken. Because once it goes abroad and it comes back, that link is broken. So the main aim will be for money laundering activity that projecting the property as untainted. So that property, it should be projected that it's not out of any criminal activity, but it is untainted. It is earned through legitimate means. So that is the aim of that. So these are the three ingredients of the money laundering. One is that there should be a predicate offense. Second is some proceeds of crime should be generated out of that offense. And third is that property, whatever is derived out of that proceeds of crime, should be projected as untainted. So these are the three ingredients. So this is the one scheme, that placement, layering, and integration I told you. So this is the how this is. This is one example of how that layering is being done and integration is being done. This is in a schematic diagram. It has been told. The same is that source of income is that proceeds of crime, whatever has been generated. Then placement, layering, and integration is being done. So basically, integration is done through these means, whatever have been mentioned here. So now with that, let's come to the definition, section 3, which Mr. Chetan Shah was also mentioning about. So this is the most important definition under money PMLA. What does section 3 say? Section 3 defines the offense of money laundering. So whosoever, any person whosoever, directly or indirectly, attempts to indulge Directly or indirectly? What does it mean? What is the meaning of directly or indirectly? Can you tell me what is the meaning of directly or indirectly? Yes. Either you are doing it directly or through someone else. Through via means through someone else. Attempts to indulge or indirectly can also means attempts to indulge or knowingly assists. So knowingly assists. So there are two words, knowingly and assists. That means a person should have knowledge also that this money is tainted money, and assists means this is not to be his own money. He is assisting someone who has already done that. Criminal activity has been done by someone else, and he is only assisting that person. Assisting how? Or knowingly is a party. Or knowingly is a party. That means he may be on the other side of it. I am opening a company, so I am making you as a director of that company. You know that the monies that are going to come in this company, they are not clean money. They are dirty money. They have been come through some proceeds of crime. They are generated through proceeds of crime, and this money is being rotated, funneled through this company. But since I am getting a good return, I am agreeing to become the director of that company. So that means so who that person becomes the party. Knowingly is the party, or actually involved in the process or activity connected with what? Actually involved in the process or activity. I may not be directly opening a company or money may not be routed through me, but I am advising or I am directly connected with that. I am telling him, I am planning for him, I am making plans for him ki how to get that done. I am talking to other people, I am getting 3 4 dummy directors. So that becomes that actually involved in any process or activity connected. Any process or activity connected. Connected with what? Proceeds of crime, including its concealment, possession, acquisition, or use. So you are involved with the proceeds of crime, including its possession, concealment, acquisition, or use. And is important because and projecting or claiming it as untainted property. And there are two parts. It one is that you are concealing it, and second you are projecting it as untainted property. So this is the definition. Untainted property shall be guilty of offense of money laundering. So not only the actual person who has committed the predicate offense, he not only he is guilty, but any person who is associated with that person in that process of money laundering, and he is helping him in converting that money, tainted money into untainted money, is also equally guilty of section 3. So that definition you should all understand, you should keep that in mind. Ki whosoever is knowingly assists. What does knowingly means? Knowingly means that you should have a knowledge. Suppose I am a politician, so I have 5 lakh rupees, 10 lakh rupees, something of that sort will be my income. It won't be if I don't have any business, independent business. So my income won't be that much. If I am investing 70 crore, 100 crore, 120 crore monies I am giving you, and you are through you I am investing in certain companies and all, or I am taking share premium. So that means ki you know the other person who is assisting, he knows that this money is not a genuine money. This money has come from proceeds of crime only. So if you assist, then it becomes ki knowingly. Knowingly does not mean ki in writing he should write you a letter. The criminal should write you a letter. Ki this is the money I have got from the murder of certain person or from the corruption. I've got this money out of this corruption case or something. So that should not be knowledge. Knowledge is that if you know indirectly also, so it will be presumed that you have a knowledge of that criminal activity and you have knowingly assisted that person. Because you have to see in the logic of things also, no? These things. If I have some business, I want to invest some monies. So then you should know what is the genuine business of this person, what is the source of this money, and if these activities are being created, dummy companies are being created, dummy directors are being created, money is funneled in this. these companies, and through these companies some assets are being purchased. So I have the knowledge this company is having some source of income which does not appear to be genuine. So that this is the knowingly. So that connotation knowingly is very, it has wider implications. So then, so any person connected with any process or activity connected with the proceeds of crime. Oh, do you have caller mic? Give a caller mic. So from the definition, it's better. So from definition, it is clear that any process or activity connected with the proceeds of crime or projecting it as untainted property shall be guilty of offense of money laundering. So I think this part is clear to all of you. Now let's go to the definition of 21U. What is proceeds of crime? Because here you see with the proceeds of crime, the word is proceeds of crime. I think I will speak in the mic only, it's better. Don't have caller mic. So what is proceeds of crime? Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of a criminal activity relating to scheduled offense or value of any such property, or the value of any such property, or where such property is taken or held outside the country than the property equivalent to the in value held within the country. So one is that property, what is the proceeds of crime? Means any property. It can be movable property or immovable property, any property. There should be a linkage directly or indirectly with the proceeds of crime of that property. And then there should be, it should be related to the scheduled offense. And then the third part is that if you have value of such property, or value of such property, or where such property is taken held outside the country, then value equivalent. So there is a concept of equivalent value also. Suppose a criminal offense has been created and I have done a money laundering of around 100 crore rupees. But that money we are not able to, investigating agency ED is not able to find that money, where that 100 crore has gone. It has been taken out in cash and then it has not been fed into the banking system. Some gold has been purchased or some benami properties have been purchased which we are not aware of. Then the value of property, value thereof, the concept of value thereof is also there. That in lieu of that property, suppose that total 100 crore is the proceeds of crime, so any other property can also be attached if there is no direct linkages. Any other property of that person, held by that person directly or indirectly, can also be attached. This provision we used in this Vijay Mallya case, this Kingfisher Airlines, we used this provision because the monies had mostly gone out of India. That 9,500 crore loan plus interest, that amount had mostly gone out of India in guise of lease payments, lease for the aircraft and other payments that had gone out of India. Monies were not available in India. Those tainted money or proceeds of crime was not available in India. It had all gone abroad. So we attached equivalent value property in India. Other properties that Vijay Mallya was having in India, with those properties were attached. Some shares were there and some flats, residential flat, commercial flat, farmhouse. So those properties were there. So the implications of PMLA are very wide and far. Not only that your property which you have earned through that proceeds of crime, that criminal activity, but other properties also in equivalent value can be attached if that property is not there. And it's not necessary that only your properties in your name can be attached. If property of a company or other things also, if we are able to prove that these properties are being indirectly held by you. There is one more section burden of proof is also there. We'll come to that also, section 23, which says that the burden of proof, once I am alleging you that you have done money laundering, the burden of proof shifts to the accused. You have to prove that you have not done the money laundering. So it's a special act, so powers are different from the normal acts. The investigating agency has to prove that you have done something. But in this act, once I allege you, I have a reasonable belief that money laundering activity has been done and these proceeds of crime has been generated. So then the onus shifts on the accused to prove that he has not done the money laundering, committed the offense of money laundering. And then in recent amendment, if the property we find that the property is held outside India, then equivalent value can be attached in India also. If we feel that property has gone out, it can be equivalent value can be attached in India also. So this is the definition of scheduled offense. 2(1)(y) defines the scheduled offense. So there were initially there were three parts: Part A, Part B, Part C were there. Then in 2011 amendment, Part B, all the offenses of scheduled offense like cheating, forgery, they were in Part B. They were also shifted to Part A. So Part B was for some time till 2015 amendment, I think. Part B was empty. There were no sections in Part B. All the sections were in Part A or Part C. But now I think with this amendment only 132, section 132 of Customs Act has been now given in Part B. Now it has come in Part B, and for Part B there was used to be a money limit. In till 2011 it was 30 lakh. So offences of more than 30 lakh were to be in only those offences where the allegation of proceeds of crime is more than 30 lakh could be registered as money laundering offence. But then in 2011 that was scrapped, and then everything is Part B came to Part A, and there was no monetary limit for any offence of any amount. If there is money laundering, then that case can be taken by Enforcement Directorate. So the PMLA is a complete code in itself. It's a self-contained law. It does not have to depend on other acts to derive its powers. All the procedure for investigation, for searches, for arrest, for cooperation from other countries, everything is for setting up of appellate tribunals, for adjudicating authority, for special court, for taking cognizance, for filing a prosecution complaint that police call charge sheet. So everything is contained in the PMLA Act only. So the courts also, there is a special procedure provided under the Act, and special authorities courts have been set up for the PMLA. So there are especially when we come to the section 5, after 4 we come to section 5. So section 5 gives us the procedure for attachment. The properties which are being generated out of proceeds of crime or value thereof, that can be attached under the section 5, provisionally attached. So the attachment order can be done by the deputy director. So for that, provisional attachment is a quasi judicial decision, so that goes to an adjudicating authority. So there is a special adjudicating authority appointed by the Enforcement Directorate which looks after the cases of attachment, provisional attachment orders. So once the provisional attachment order is being issued by the Enforcement Directorate, we file a original complaint in the adjudicating authority, and then adjudicating authority gives chance to both the sides. It gives notice to the accused also, or any person who is related to that property, it gives notice to them, and it gives notice to us also. And there is court deliberations are there. Then after that, within 180 days, court can this adjudicating authority can either confirm the provisional attachment or can release the property also. So that is a special mechanism provided under the PMLA that I mentioned. There are two parts of it. One is that akin to the civil process, which is that attachment and all, and second is filing of prosecution complaint. So this section 5 provides for the provisional attachment of property involved in money laundering. So then there is section 8. Before section 16 we come with, there is section 8. So once that provisional attachment is being done, has been done by the officers of enforcement directorate not below the rank of deputy director, then we file an original complaint in the court of adjudicating authority. So adjudicating authority has to pass an order within 180 days, and once that adjudicating authority passes an order confirming the attachment, provisional attachment, then the provisional attachment becomes final attachment. And once final attachment is done, then possession of the property also comes with to the enforcement directorate. We have to take the possession of those properties also. So the aim, the basic aim of the act is that criminals should not enjoy the fruits of proceeds of crime, fruits of crime. They should not enjoy the fruits of crime. We should, whatever properties have been earned by a person through his criminal activity, he should not be able to enjoy those properties. So they should be attached forthwith, and they should be used by government also. In other acts, if you see, then after attachment till the final confirmation, the property remains with the person only. But here, the property is immediately taken by the enforcement directorate as per section 8.4. Eight four says, where the provisional order of attachment made under subsection 1 of section 5 has been confirmed, the director or any other officer authorized by him in this behalf shall forthwith take the possession of properties. If it is not practicable, so that is the, so immediately after that order of confirmation, that in any case has to be done before 180 days. So the possession of property also goes with the enforcement directorate. Then comes the section. Actually, this PMLA Act governs the functioning of enforcement directorate and also the FIU India, Financial Intelligence Unit. They also derive their power from the PMLA Act only. They have been constituted under PMLA. FIU was established in 2005 under PMLA Act only. So section 13 gives that. Section 13 and 14 and 15, these three sections of the PMLA Act deal with the powers and powers of the FIU India. Then we have the powers of survey. Section 16 is for the survey. So survey means non-intrusive. If we have some information, we don't use it much. The survey provisions are not being, because normally we go for search only. But if we feel that there is no information is not sufficient, or we don't need to search that premises, then survey can also be done. So the survey can be done only in the jurisdiction of the officer. Suppose I am joint director of Mumbai, so I can do survey only in, my officers can do, I can authorize them to do survey only in Maharashtra. So the next provision is search. Section 17, search and seizure. So if we have reasonable reasons to believe that any offense of money laundering has been done, and then if proceeds of crime, any person is in possession of proceeds of crime or any record relating to the proceeds of crime, then search can be conducted. So search is conducted on the authorization of joint director, and it can be, search warrant can be issued in the name of assistant director. So the search assistant directors are empowered to conduct the searches. Search of person can also be done under section 18, wherein we need that a person is hiding, secreting some documents, or it is there some valuable information, something is there, he is hiding something, or then a search of person can also be done. Then comes the power to arrest, the most important here, the power on which this debate is also going on in High Court also in Chhagan Bhujbal case. So there are Under section 19, the assistant director, our officer of the rank of assistant director, is empowered to arrest any person. Which for what is needed for arrest? One is that he should be in possession of material basis of he should have some investigation done on which basis he has some possession of some material indicating what does it indicate? There should be a reason to believe that the person is guilty of offense of money laundering. So if our IO investigating officer, that is assistant director, has some materials in his possession on the basis of which he has reasons to believe that some person, such any person has done something, is guilty of offense of money laundering, then the arrest can be done up. That other person can any person can be arrested. What are the precautions after arrest? Only that grounds of arrest have to be communicated to that person. Whosoever has been arrested, what are the grounds of arrest? It has to be communicated to the person. And then adjudicating authority has to be informed immediately. Adjudicating authority, which is formed under section 8, which we are talking about, adjudicating authority confirms the attachment or provisional attachment of property. So that authority should be informed immediately, and within 24 hours the person should be produced to the court. So these are the powers of arrest. But now with this we have to read it with the section 45. Once the person has been arrested, what are the conditions for bail? So the provisions of bail is very stringent in PMLA. Normally a person does not get a bail because there are two conditions that should be satisfied. Court should be satisfied about two conditions before granting bail to any person. First condition is that the public prosecutor has been given an opportunity to oppose the application for such release. So behind my back, no one can be given bail behind my back. I am not present and then the court calls the accused and then gives the bail. That is not possible. You have to give a notice to me, then I will be represented. I will put my facts forth with the judge. Judge has to listen to that, and then only decision can be taken. And second, where the public prosecutor opposes the application, suppose I oppose the bail application, the court is satisfied that there are reasonable grounds to believe for believing that he is not guilty of such offense. The court should be satisfied. It should be satisfied of what? Court should be satisfied that the person is not guilty of offense of money laundering, that the arrest is prima facie illegal, ex facie it's illegal. I have arrested him without any basis, without any ground, without any reasons to believe anything. So that in such cases, when the court has the reasons to believe that he is not guilty of offense and that he is not likely to commit any offense while on the bail. One is that he is not guilty, then he is not guilty of any money laundering offense. But second is and when he is released on bail, he is not likely to commit any offense while on bail. So these are the two conditions. So if I oppose bail, then the court should be satisfied to that investigation is a farce. There is no offense of money laundering against that person. Court should be satisfied. And then if he comes out on bail, then he will not again commit the offense of money laundering. So the provisions of bail and the provisions of arrest and bail have been made very stringent because we are not dealing with the normal criminals. We are dealing with the people who have money power also, who have influence also, and who know how the system works and how to tweak with the system to their benefit. So for that, this 45 and section 45 and section 19 have been provided. Then section 50 defines the power for summons. So enforcement directorate officers are not the police officers. So any statement that is given before the enforcement directorate is considered to be true and truthful and correct, and it is evidence, it has evidentiary value. Evidentiary value, when I say, then evidentiary value has two meanings. One is that it will be admitted as the court evidence in the court of law. But it's not that I tell anything, I say anything, it will be admitted in court of law. It should be corroborative also. It should match with the whatever the criminal offense has been taken, or some independent evidence should be there. So it has to be matched. Corroborative value should be there. Otherwise, whatever I say, it can't be. But to that extent, if it is getting corroborated with the whole story, or if it is getting corroborated with the facts, or to the bank account, to the other statements, to the money laundering scheme, to the this, so then it becomes a admissible evidence in the court of law. So that is the, because enforcement directorate officers are not the police officers. So then section 41 and 67, they expressly bar the civil courts from the 41 is civil court will not have any jurisdiction in the criminal cases. In our PMLA cases, civil courts do not have any jurisdiction. And 67 says that bar of suits in civil court. No suit shall be brought in any civil court to set aside or modify any proceedings taken or order made under this act, and no prosecution, suit, or other proceeding shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. So civil courts do not have any power or jurisdiction over the money laundering offences and investigation. So basically there are only two courts. One is the special court that has been formed. In every city there is a court which is designated as the special court. So special court has the power, and against the order of the special court, high court and supreme court. So three courts, only three courts have the power over the, or jurisdiction over the PMLA cases, money laundering offences. This though we have already talked about independent adjudicating authority. So the trial, so what happens, the first aspect was that attachment. That attachment, it goes to the adjudicating authority. And second, when we complete our investigation, then we file a prosecution complaint. So we file the prosecution complaint in the special court, PMLA special court, prosecution complaint is filed. So after the prosecution complaint is filed in the court, so that we have certain number of accused and certain number of witnesses are there. We have to define the role of each of the witnesses, each of the accused, what is their role in money laundering, how they are connected with the money laundering, what is the proceeds of crime, where the monies have gone, and what are the whatever attachments we have done. We have to give the list of attachments also, and how these properties were connected with the offense of money laundering. So with this, all this data and everything, we file a prosecution complaint to the court, special court. And with that prosecution complaint, our prayers are twofold. One is that whatever properties have been attached by us, they should be confiscated by the special court to the government. The property should come to the government. And second is, the person should be punished for the money laundering offense. The offense is, as we know, 3 to 7 years of punishment is there, and fine is also there. A fine can also be levied. So then the trial starts in the PMLA special court. So first that cognizance is taken, then process is issued, then all the accused, they have to come to the court. The court can issue summon also, court can issue non-bailable warrant also. Like in the previous two cases, in Chhagan Bhujbal case and in NSCL case. So the non-bailable warrants were issued by the court. So if the court feels that the accused will not come to the court on their own, so then it will issue a non-bailable warrant against the accused. So in Bhujbal case there were around 33 total accused persons were there. Companies were also there. I think total 54 or 55 were there accused, but 33 persons were there. So barring two who were in jail, Chhagan Bhujbal and Sameer Bhujbal, others were non-bailable warrant was issued against the other 31 persons. So once that people come to the court, then court frames the charges. So the charges are framed. What are the offences? What are the charges? So charges are framed, and then trial for the money laundering starts. Money laundering offence. Here one more important thing is there, that the police also is investigating the case. FIR is there, so they also file their charge sheet. So their trial will also go. So they can't be in two different courts because of money laundering. So we have to file for the transfer application also. The predicate offence trial is also transferred to the special court. Suppose they have filed in the Dahisar police station, that charge sheet has been filed, then we will request the Dahisar judicial magistrate to transfer that case to the PMLA special court. So both the trial run concurrently. Like in NACL also, there is one special judge only who is conducting trial for both the MPID also and for our PMLA offences only. So the same judge does the trial of the both the offences. So there were, I think mostly we have covered the topics. So any query or doubt or anything you want to ask until now? No, PMLA special code does not follow CRPC. We have, I will just tell you 1 second. CRPC is applicable up to that extent which is it is not inconsistent with the PMLA. Till that only. Yes. No, the trial will be separately. No, for money laundering, same judge will be there, but both the trials will be done separately. Money laundering offence is different. Trial under money laundering will be different, and trial under the predicate offence will be different. So they are two separate proceedings will run concurrently before the same judge. Even the accused may not be same. The accused in the predicate offence, there may be more number of accused or less number of accused. In our PMLA prosecution complaint that we file, many of the persons who are accused of criminal offence may not be accused of money laundering. Depends now whether proceeds of crime had been generated or not. Or suppose those persons who have helped him in this money laundering, the laundering of money and projecting as untainted, so they will also come under us. We will file charge sheet prosecution complaint against them also. They may not be accused in the original offence. So there are two separate processes which are being tried by the same judge but tried separately. Yes, Indian Evidence Act will apply. Yes, strict rule of evidence.
In the definition, in the first part, it is mentioned that indulge directly or indirectly.
Yes.
That the prerequisite of knowledge is not there. So what exactly is the indulge? Because in that case, knowledge is not the prerequisite. So it is a little risky.
No, ma'am. Indulgence means who is the actual perpetrator. Suppose I am laundering the money. I am doing some criminal activity. So for me, knowledge should not be there. No? For me, it is not important to have knowledge. The knowledge is only important for those who are assisting me in the crime. If I am the person who has done that criminal activity, so for me, knowledge is immaterial.
But it is telling directly or indirectly. Here,
Yes.
Indirectly, you mentioned that whether yourself or through others.
Yes.
Now, indulgement also include indirect assistance, or that's why I am asking this question. Because if you are advising also, are you indulged?
No, you are not indulging, but you are assisting. No?
I am assisting.
Yes, you are assisting.
Because indirect indulgement, the indirect word is there, so that's why I am clarifying.
Whosoever directly or indirectly attempts to indulge.
Even attempts to indulge.
Even
if you are fail.
Attempt to money laundering is also an offence. We have filed prosecution complaint in attempt also.
So this knowledge is the only very good, defense which is missing in this. So indulgement and indirect word interpretation is very crucial for this. That's why I am asking.
Correct. So that indulge.
Where the property is provisionally attached, but it is already transferred 3 months ago to somebody, either for valuable consideration or without consideration, just to defraud the attachment. Now, in such cases, whether the provisional attachment will be valid. That is one thing. And secondly, whether the brokers through whom the property are sold, that means they are also propagating the crime. Whether brokers can also be criminal offenders. They can be offended.
So you have two queries. One is that first part is that suppose we have done an attachment and the property has already been sold before the attachment. So that is generally it's not possible because once we do the attachment, before that we do the physical verification and we write letter to the registrar also that this property is not to be sold, alienated, third party rights should not be created. And just before attachment we do the verification. So normally it is not possible for us to do certain attachments which we have where the property is not there in the possession of that person. But suppose that happens, sometime it can happen also. Suppose that we have done certain attachment and to defeat the purpose of attachment that fake sales has been created or it has been sold to, there can be two possibilities. One can be there can be a genuine sale also. The other party to whom the property has been sold is unknowingly he has bought that property. He was not knowing about that criminal past or whatever attachment order or the criminal activity or that the property has been generated of the proceeds of crime. So in that case, whatever monies have been transferred, so then the transaction will be genuine. So whatever the value of the properties will be there, that value of property will be taken by the our person, whosoever our man, he will take the whatever value will be there. So in that case, we will attach the value that has monies that has come to that person, which has come to him. So that value will be that property will be attached if that money is still lying with that person. But then the attachment order will not be valid anymore. Second possibility is there ki you have only the person has only raised the second person is also dummy person only. It has been created by this person only to alienate his property. So in that case, the property that attachment will be valid because we will be able to prove that there was no financial consideration or there were considerations which are more than the financial consideration. So that then the property attachment will be valid. Your third point was that whether that broker who has brokered the deal will be fall under definition of section 3 or not, whether he will be guilty of offense of money laundering or not. So that again depends on the knowledge, whether he was knowingly done this transaction. In this we have one example. In city limousine case we attached development rights of some properties. So even our after attachment, after statements of the broker was also recorded. So even after attachment, he sold that the broker sold that property to the development rights of the property to the third party, new customer. Even after so in that case, the broker was fully aware because his statement was also recorded by the enforcement directorate. He was fully aware that property is tainted. The property has already been attached provisionally. So even after that, he sold that property by taking power of attorney. So in that case, that broker was also guilty. So that in the prosecution complaint, name of the broker was also included, and then whatever monies that were received by the broker and by the person guilty of money laundering, that was also attached. But the property which was sold to the third party, since they were not knowing about that background and since they had paid all the money, so the property became untainted, and then he was the other person who was not involved was able to enjoy the property.
In the court to proceed.
Actually, sir, the problem is that the special court is there, but it's not exclusive. The special court is handling other cases also, so that is why it is taking time. But PMLA because 420 is there, no? Cheating and criminal conspiracy is there. 120B and 420 have been invoked, so it is involved. Correct, sir. We brought up this issue. We took up this with the judiciary also, but they say that they are very short of manpower, so they can't give so they can't give us exclusive. Of course, if you are knowingly assisting him, suppose. Yes, yes, yes. No. How can he not know if he's become a director of a company, he's getting some 5,000, 10,000 rupees per month. How he does not know? Why will anyone give you? Then he has to admit that, no, I was forced by Mr. Such and Such to become a director of that company, and then he should reveal the truth. Then he can become an approver. And then the chartered accountants, you suppose what had happened. I have opened certain companies. I have opened 2, 3 companies. Company is only paper company. There is no activity in these companies. So I have 10 rupees share of that company. And certainly the other day the value becomes a premium. I'm selling that at premium of 10,000 rupees. 100 rupees share at the premium of 9,900 rupees. Okay, and I'm getting 50, 60 crore, 70, 80 crore rupees through that premium. And that companies to whom I have sold these shares, they're all dummy companies. There is only addresses. No one is there at those addresses. And those companies, when we go to those companies, some of them, if we could find them, they tell that we have received cash, and then we have given them the entry of this thing. We don't know anything about the shares. We have not purchased any shares, anything. We have just given them an accommodation entry, and CA has helped in all this. So the CA is guilty or not?
Sir, Section 24 of PMLA,
Yes.
it talks about burden of proof. It shifts the burden of proof on the person who is alleged to have committed PMLA.
Yes.
Now, as such, presently, tax evasion is not an offense, which is in the schedule.
Yes.
Now, but what prevents the PMLA department or the officers from issuing a notice to a person and make an allegation that according to us, let's say the current case of deposits coming into this Jandan accounts or any other bank account, and just issuing a show cause notice that please show us that the deposits which have been made, they are out of tune with your known sources of income and they are not proceeds of crime. And thereafter the burden of proof will shift onto that person.
No. It can't be done. See what is Section 3 says? Connected with the proceeds of crime.
Right.
What is proceeds of crime?
So it is true, but
proceeds of crime is any property derived out of result of criminal activity. Criminal activity should be a known criminal activity. Criminal activity is what? It's not that I have murdered someone, it becomes a criminal activity. It will become criminal activity only when FIR is registered. Criminal activity for us is a criminal activity when that FIR has been registered, a report has been registered. Suppose you are very right. Suppose corruption, money is of bribery, of corruption. So that criminal activity exists, you will say that criminal activity exists. But the criminal activity does not exist. Criminal activity will exist only when the FIR has been registered against that person, against the Prevention of Corruption Act. So before that it can't be taken. We can't take that case. So until and unless there is a predicate offense existing, investigation under PMLA cannot happen.
So not on the basis of suspicion.
No. Suspicion it's a special act. You can go to jail. You won't get bail for 3.5 years on suspicion. It can't be, no.
No.
Person can go to jail.
No, mere issue of notice. I am only saying an issue of notice.
No, notice. Why notice only then? It can be arrest also. Why only notice? Why to? It can be anything, no. Once you have started investigation, then there is no stopping. It can be anything.
If there is already an offence registered, as I understand, there is an offence registered with the local police station. On that offence, PMLA can be, ED can separately start its own proceeding. But is that on a complaint by somebody, or the or the ED takes suo motu cognizance?
No, it can be taken suo motu also. It can be on the basis of complaint also. The only thing is that we have limited manpower, so all the cases cannot be taken up.
And there is no separate FIR registered by the ED?
No. We have this ECIR.
Okay.
But it's our own documents. We don't submit it to the court. FIR is what? FIR you have to give it to the magistrate within. No, a copy of it has to be given to the magistrate.
So the example that you gave, that you opened a bank account with 5,000 rupees and soon you get 50 CRs or 60 CR, the share of 10 rupees is sold at 10,000.
Correct.
We all feel that is an extreme example that you have taken. Yes, and in these cases, the chartered accountant should be penalized, should be prosecuted. Yes, because he has been a part to all this.
Yes.
So, but take the case of a average chartered accountant in India, like all of us. We all genuinely try to do practice. Now, what precaution, according to you, should be taken by us for our clients? Now, if a client comes to us who is having a taxable income of say 50 lakhs or 40 lakhs in salaried cases, their relatives are in UAE, which is a very hotbed for the department. Once you think of UAE, you only think of PMLA. The most genuine cases are also scared to invest in India because of PMLA. Sir, in these cases, can you give us some guidelines what a chartered accountant should do? What precautions should we take? What details can we take? Because the bank asks for KYC in India and KYC is met. Then beyond KYC, then what else a chartered accountant can take a precaution? Can you talk something of this, sir?
So only thing is that you keep your relation at the professional level only. Whatever advice is there, you give them genuine advice. There is no harm in giving genuine advice. But once you become more than an advisor, and for a fees which is more than whatever is the reasonable fees, then it becomes a problem.
Sir, with all due respects to all chartered accountants, the fees varies from 0 to crores.
Whatever it is.
Because a young chartered
It can be
accountant
anything.
having passed his CA exam just yesterday would love to get a foreign client FOC. Whereas the other clients who are in practice from 40 years, I don't want
Yes,
to
sir.
talk about them. So fees, sir, according to me, can you give some basic guidelines that what documentation we keep? And just to keep ourselves safe.
Source of money is the most important thing, I think. Then you should inquire about the source of money. What is the source of fund, whatever. You gave example of FDI. Correct. Money coming from Dubai and all. So in that you don't have any control on source also. What is the source of that company and all. So it should not be $1 company maybe. You can see that it's a company, established company. But I don't think that is your area to look into it. As long as prima facie you are satisfied that this source appears to be genuine, then I think it's fine for the chartered accountants. Only thing is that there is gross negligence or gross connivance is there. No? If there is a connivance between them, between you and your client, then it becomes a problem. Otherwise, you are free to give advice to whatever legal advice is there. You are free to give legal advice to anyone. You are free to take any remuneration, whatever is genuine to you. But only thing is that there should not be any connivance, or there should not be any, after even knowing explicitly that this is the money, source of money are suspicious, or there is no source of income for this person to generate this much of money, this much of account. And I think from your level, it's very easy for you people to find out that, to ascertain whether the source appear to be genuine or not. You have X-ray, you can find out. I think from the person whether that person is genuine or not, or money is genuine or not. Because what happens in that? Suppose I have some proceeds of crime or some money from the corruption or something. I will take any return. In US, what happened in USA? Once they started a new methodology, they said that all the properties that have been purchased in New York without any loan, prime properties purchased without any loan, they will look into those properties, and most of those properties were found to be out of proceeds of crime or the money laundering activities. So what does this indicate? It indicates that a process which is not genuine, which is not usual, if those processes are being used, then it means that there is something what more than what meets the eyes. So you have to be cautious. There can't be any straitjacket answer to this key at all. You should all be cautious, and you should all be, at least you should be able to justify your, whatever advice has been given, you should be able to justify your advice. Yes.
Section 420, fraud and cheating are one of the most commonly used sections while you file an FIR. In that case, how is the ED to make a discretion of what genuinely constitutes and what cases should one look into and what should not? Because then there can be a gross abuse of power and there can be a gross misuse of power if every person who was to push an application to the PMLA on the basis of 420, then there would be this would be quite
Yes.
draconian. So how does
Yes.
one exercise? How does the ED exercise its discretion?
We have one is that we have our internal guidelines regarding that which cases are important to us and which cases are to be registered and all. We have internal guidelines. Secondly, the approval of registering a case under PMLA, that ECIR, has to be approved by the special director, who is very senior officer. So it's not that any assistant director can register any case based on that 420 or cheating. So it comes from the very high level officer, and hardly there are not many cases. And thirdly, we generally don't register case between two private parties. One side has to be government or some investors or some cheating or some large scale cheating. Something should be there. Normally, we don't register case against two individuals. Suppose today I am making an allegation and against you, and after some time we settle out of the court. What happens to the case? My case goes, no?
Thank you.
So the arrest, search, or seizure that can be done only after the ECIR is registered.
Yes.
Prior to that, and so
No.
is the accused entitled to a copy of the ECIR?
No, he is not. It's our private document.
Right. So, but on what grounds is he then to plead for bail, etc., if he does not have a copy of the allegations
Grounds
against?
of arrest will furnish him. No? Whatever grounds of arrest will be furnished to him. In the remand application also we will mention what are the grounds of arrest. So he can plead on that. Mhm. No, you have to be. One is that what advice you are giving. If advice is genuine, you are asking whatever money has come, you are asking him to invest in LIC. So then what is your problem? This source of no, even if the proceeds are from wrong activity and you are giving him a genuine advice without knowing, then I don't think there is any problem in that. Only thing in that we are when you are helping him in making it untainted or something, you are structuring some deal for him, or you are making some companies for him, creating some companies or something, or you are creating an alternate source of revenue generation on paper for him so that these monies are being accounted for, then only you are knowingly assisting him. It's not that in genuine case, general case, someone comes to me, I tell him something that it does not become in genuine bona fide manner. If I advise someone something, then it does not become a crime, criminal. Yes, it will be unknowingly.
Sir, you mentioned about internal guidelines.
Yes.
Now, can we have a copy of the internal guidelines under Right to Information Act?
Actually, RTI is not applicable to Enforcement Directorate. So.
Sir, I think the question that they are trying to ask regarding the safeguards that a chartered accountant, when he is practicing as a professional, that he should adopt. I understand that there is a very thin line between what you know and how you behave. But if you can just throw lights on some cases where chartered accountants were arrested and what were the grounds for arrest, so that would help us to understand that what precaution we could take or what kind of activities we should not indulge into to safeguard ourselves as professionals.
See, there are two cases are there. One is that I have already discussed you. Some companies were opened and share of 100 rupees were sold in 10,000 rupees. And money had come from some dummy companies in Kolkata, Coca companies. And then the chartered accountant was also aware that the money was given in cash to these Hawala operators. In fact, he was the one who introduced these operators to the person concerned. So, and through him only these monies were transferred to the in cash were given in bags and bags to these Hawala operators, the company operators from the Kolkata. And from them the money came into check form in the company. Second case was that there was a company in Navi Mumbai which was doing some software export was its business, but it was not doing well in the software export business. So they needed some money to show their transactions and all. So what they did is they created debtors and creditors on the both sides. They had to receive money from some people and they have to give some money to the some people. So when the cash came, so cash was given in the third layer of the company, debtors. It was given. The cash was given to debtors. From that money it came to the check in the software company. and then that software company gave advance to this company for purchase of properties, whatever for the flat booking or whatever was the purpose for purchase of land. Some fictitious thing was created, and then when after 2 years their business was this project was made, and then they sold the flats and all, then the same in the same fashion it was sent to the creditors, and from there it went to the company. So this structuring of this was done by the chartered accountant. He did the structuring of the this whole scheme of the things. So 40 crore came, and then 40 crore went after 2 years. So the money was given in cash. So you got an entry, your cash came into your company, then you earned some profit, and then when you generated some profit, then money again was returned. So this was the second point. And third was that one chartered accountant was that filing that annual return of the 6 7 companies. So then all the assets and everything was fudged. He himself told that I take 10,000 rupees and then I sign wherever they tell me. I sign there, and then I get just 10,000 rupees remuneration for that. So that is the duty of the chartered accountant to verify the factual correctness of the returns, at least on the random basis or sample basis, whatever your instructions are, guidelines are, you have to follow that. If you are so reckless that for 10,000 rupees you are signing anywhere, then you are inviting trouble. But let me assure you that we do not we do not want any chartered accountant, or for that matter any other person, to become an accused, because it really makes life difficult for us also. You are making so many accused, and it becomes difficult for you also to get the to take the case to the logical conclusion. So until unless there is a direct nexus between the chartered accountant and the accused person, until unless there is a direct nexus between them, we don't make them an accused, co-accused. Second category is witness also. We can make them a witness to, if want to understand the system or something, or if we want them to reiterate the returns or something or their advice, so we make them witnesses. But in the extreme cases, when they are involved in with the proceeds of crime, or they are advising us, structuring them their cash for conversion of cash into the check, of a conversion of cash, illegitimate income into a legitimate income, then only a chartered accountant can also be made an accused. But the norm is that we don't make them an accused.
The second case which you said about structuring and cash check and all that was knowingly done by.
But how can the cash can be unknowingly cash can be converted into check? Cash cannot be converted into check unknowingly, no? Because what will the source of the cash? Proceeds of crime. Yes. Yes.
Under VAT department, they have a blacklist available on the website. Dealers blacklist. So one can know easily that this is not deal with.
No.
Certain type of things, whether ED website or PMLA website.
No, we don't. No, we don't have. Any more questions? AML officer, yes. Every bank has AML officer. I will just. No, there is one presentation on this also. I will just give you. See, there are 2 3. One is that I just have one this also. I have presentation, maybe 1 or 2 slide I will show you. So you will get to know about that. This projector is not working. Actually, basically, no, there are 2, 3 types of report that are being generated that are being mandated by the FIU. One is that suspicious transaction report. One is cash transaction report. So cash transaction report is all cash transactions of more than 10 lakh rupees in a year, if there it is there, or all integrally connected cash transaction aggregating more than 10 lakh rupees in a month, or more than 50,000 rupees of transaction in one go when you have to give PAN. So that report is generated and is sent by the banks to the FIU. One is cash transaction report. Second is suspicious transaction report. So suspicious transactions means transaction or including attempted transactions which gives rise to the suspicion that it may involve proceeds of an offence specified in the schedule to the act, or appears to be have been made in circumstances of unusual or unjustified complexity. Suppose same 10 crore rupees, I have company A, B, C, D. In one case we encountered there are 4 companies A, B, C, D. So 5 crore went to A to B, same day it went to B to C, C to D, D to A. And this way it was rotated 5 times. 5 plus 6 times. So 29 crore was totally rotated in single day between 5 entities. So this kind of complex transaction which do not have any economic rationale, no? Unjustified complexity. Why will the same money will rotate in 5 companies? Because either you are trying to create some this volume or turnover, or you are trying to, suppose I have property is mine. I have purchased a property. I am giving that money into, I have to give you 10 crore rupees. But that property is also mine and this is also, suppose I purchased a property in your name. 5 years back I purchased a property in your name. But that time also investment was mine. After 5 years I want to take back that property from you. Now that value of that property is 5 crore rupees. I have only 50 lakh with me. So what will I do? I will rotate that 50 lakh 5 times, 10 times. I'll give you check, you give me cash, again I'll give you check. So that kind of unusual or unjustified complexity, these kind of transactions. Or the transactions which have no economic rationale or bona fide purpose. I've opened a new company of 10 lakh rupees and suddenly my turnover goes to 100 crore. I start giving import advances of 30 lakh, 40 lakh US dollar I am giving import advances. So that rationale or this is not there, no economic rationale or bona fide purpose. A newly opened company, it is having turnover of 50 crore in just 5 months or 2 months or 3 months. So there is no economic rationale to this. Then those transactions which give rise to suspicion that it may involve financing of activities related to terrorism. Some monies are going to some banned organizations or monies are coming from places which are prone to terrorism. So that thing is there. So basically on these parameters, STRs are being generated in the banks. Yes, NBFC also. Yes, list is there. Yes. Yes, yes. Yes. Their no value 7.59 crore CTRs were generated till May 2016. So large amount is being generated. No, I think it is in total. About cumulative, it's cumulative, yes. Above 10 lakh as. I think 50,000 is not there. 10 lakh is there. 10 lakh is there. No, it's saving account only, not current account. Cash deposit only, not withdrawals.
Is also the same part of your team only? ED is also part of your team? Enforcement director?
Yes, Enforcement Directorate is
Is a
we
part
are
of
from.
your
I'm from Enforcement Directorate only. No?
so no, so ED means all ED, the ED means they are all part of
Enforcement
enforcement
Directorate.
director
Yes.
only.
Yes.
And so there's one more organization called Serious Fraud.
SFIU.
Is
SFIU
also part of
no. SFIU is under Ministry of this Commercial Company Affairs, MCA.
Okay.
It's under MCA.
All right.
Yes, we implement two acts only, FEMA and PMLA. Both acts are being implemented by Enforcement Directorate. ED means two acts. No, it will be with income tax. Correct. Actually, FIU is a separate entity. We are not. No, it comes under PMLA, but there are two agencies under PMLA. One is FIU, one is Enforcement Directorate. So FIU generates reports and all. They have their own different setup. Ours is Enforcement Directorate. We have different setup under PMLA. Yes. Yes, different verticals. Section 12, 13, and 14. No, we talked about that. So those empower this FIU. Maybe for FIU, we don't prescribe anything, so I'm not aware about that issue. Those will be prescribed by FIU, and FIU is different department, so we are not. Actually, I'm not aware about such forms and anything.
Yes, thank you, friends.
Friends, you will all agree that Mr. Kumar went through the PMLA Act in detail and also answered, in fact, all the questions asked by this forum. He told us about the special law, the special purpose, the special court, and he's also a special person. His name says Satyabrata Kumar. Satyabrata, I was going through the dictionary, says a brother, truth of brother, actually, That means his passion is to go to the truth, and he has to really regulate two very tough laws, FEMA and PMLA, actually, where there are only crooks. The society is running a petition on ICDS, scrapping of ICDS, and we have mailed to all members to sign that petition to go to the government of India. Till now we have got 1200 signatures, and our aim is to reach 5000. So I request everybody, those people who have not signed the petition, please go to the website and sign the petition and do the needful. Before I request Kinjal to make the announcements and vote of thanks, I'll request him to hand over a small photo frame on behalf of the society to Mr. Kumar. Kinjal.
Good evening, friends. Before proposing a well-deserved vote of thanks, some announcement for the forthcoming meeting. Friends, we have a lecture meeting which is scheduled on 9th of December at 6:15 p.m. here at BCS Hall. It's a very interesting topic which is on cybercrime, cyber security, and cyber laws, especially with a lot of people now going cashless. We are going to see enormous increase in these crimes, and how do we safeguard ourselves. But all the more, we have a very interesting speaker who is be there, and he is the Deputy Commissioner from the Economic Offence Wing Cybercrime Cell. And the most interesting fact about him is he is a chartered accountant by qualification. So he is going to educate us and share his knowledge, and especially the recent cases which has happened like the Karina Kapoor's return being filed by somebody, and lot of credit cards being forged. I mean, the systems were hacked of Axis Bank and those kind of news. I'm sure it's going to be an interesting meeting, and request you all to join it. Apart from that, we also have a very interesting program coming up for the student, which is a 2-day orientation workshop. And the orientation has been designed considering that students already undergo an orientation before they start their articleship at the ICI. So what we have done is we have identified certain areas which they lack, or which are found to be very important to be great to perform very well during their articleship. So that gap is going to be filled during this workshop, and we request all our members to encourage their articles to join for this program. The program is on 9th of December, 8th and 9th of December, which is Thursday and Friday. 2 full day program. Again, you can visit the website and circulate it amongst the CA students in your office. Friends, as we come to the close of this lecture meeting on the important aspects of PMLA and its implication on the assurance and advisory services provided by chartered accountants, it's my pleasure to deliver the vote of thanks on behalf of this august gathering to the learner speaker, Mr. Satyabrata Kumar. Friends, I'm sure we are all relieved from his assurance that as far as possible the chartered accountants are not framed unless they have actively collaborated uh, in the money laundering crime. But sir, it was indeed a very momentous occasion and indeed our privilege to have you at BCS on a topic, especially its implication in the wake of demonetization, because a lot of news article coming up saying that the enforcement directorate is also going to investigate the violation under demonetization. And your in coverage provided an insight into the legal framework under the PMLA, which covered the definition of the money laundering, the process how the money is laundered, the powers of the regulatory bodies like the enforcement directorate, and especially your real life examples because of your in-depth knowledge. And you also took the pain to answer all the queries of the members present here. I am sure, sir, this interaction will go a long way in boosting the confidence of an ordinary citizen in the government and its governance with the assistance of a powerful tool like PMLA. On behalf of BCS, I wholeheartedly express my deepest appreciation and profound gratitude towards Mr. Satyabrata Kumar, the Joint Director of the Enforcement Directorate, for accepting our invitation and sharing his valuable insight on the subject. I, on behalf of Bombay Chartered Accountants Society, request you all to join your hands and propose a well-deserved vote of thanks with a loud round of applause. Thank you. Thank you all.